Imagine you wake up one morning, you open your phone, and you see messages from your staff. Sir, our office has been locked. Or you hear that someone was selling your product under your brand name. Same logo, same colors, same packaging. And customers are confused. Before you even finish asking what is going on, you're already losing money every minute. That is where injunctions come in. Injunctions are one of the most powerful emergency tools the law gives a business owner. They are like the court saying, everybody stop right now until we properly hear this matter. If you own a business in Nigeria, big or small, you need to understand this. Because many business problems are not solved by shouting, police reports, or long arguments on WhatsApp. Some problems require speed. Injunctions give you speed. Today, I'll break it down in very simple terms with real life stories from clients I've worked with, so you can see how this works in practice and how you can save your business from collapse. First, what is an injunction? An injunction is a court order telling a person or company to do something or to stop doing something. Think of it like a legal pause button. When the court sees that a situation can destroy a business, if allowed to continue, the court can step in and freeze things for a while. There are different types. Let me explain in plain language. The first type of injunction is an interim injunction. This is the emergency one. You file your case in court and the court gives a short-term order, sometimes for a few days, sometimes till the next court date. It is to stop things from getting worse immediately. The second type of injunction is an interlocutory injunction. This is a longer temporary order. It lasts while the case is going on. The case may take months or even years, and the injunction keeps things stable until judgment. The third type of injunction is a perpetual injunction. This one comes at the end of the case, after judgment. The court says, from now on, forever, you must stop this act. Then there are special ones used for protection of businesses, like freezing orders to block someone from hiding money, or orders to search and preserve evidence. I'll touch on those later. Now let me show you the value of injunctions from the stories of some of the clients I've worked with. A landlord wanted to kill a business overnight. A client came to me, a very calm woman. She ran a fast-growing pharmacy. She had built the business from one small shelf to a full store. One evening, her landlord served her a notice, not even a proper notice. And by weekend, he arrived with area boys and said that everybody should vacate the premises. Why? Another tenant offered him a higher rent. That was the real reason. But here was the problem. Her shop was not just a shop. It had drugs that needed proper storage. It had sensitive equipment. It had customer records. She also had staff, salaries, suppliers, and her reputation. If that shop closed for even 2 weeks, she could lose her license, lose her customers, and lose her goodwill. She was shaking when she said, "Barrister, if they lock this place, I am finished." We went to court immediately. We filed an action, and we filed an interim injunction to stop the landlord from ejecting her until the court heard the matter. The judge granted it quickly, thankfully. The next day, we served the landlord. Now imagine the landlord standing at the door with his boys, and we showed him the court order. He could not move. The law had placed a shield over her business. That one order bought us time. It saved the business from sudden death. And later, when the full application for interlocutory injunction was heard, the court extended the protection until the case was determined. The lesson is that if a threat can destroy your business before trial, an injunction is your first line of defense. Let's move on. Now, I had a client who had a copycat competitor. She was into cosmetics. She had worked hard on her brand. Her packaging was unique. Her name had become popular. Her product was moving. Then she discovered that someone had started producing a similar product with almost an identical name and label. At first, she thought it was a coincidence. But when customers started calling to complain about fake quality, she realized it was deliberate. Her sales dropped. Distributors were confused. Some even said, your quality is no longer the same. This is the kind of damage money alone cannot fix. Because even if you win later, your reputation may already have suffered. We filed a trademark and a passing off action. But we did not stop there. We asked the court for an interlocutory injunction to stop the competitor from continuing to sell those fake products while the case was still going on. The court asked us to show that there was a real legal right to protect, that the case was serious, that the damage would be irreparable if the copying continued, and that the balance of convenience favored my client. We provided evidence, pictures of the products side by side, customer complaints, and proof of her prior use. Needless to say, the court granted the injunction. That meant the competitor had to stop production and stop sales immediately. The sales of my client recovered. Her brand confidence was restored, and my client could breathe again while the case continued in court. The lesson here is that injunctions are a powerful tool against brand theft and unfair competition. Now let's talk about money. A business client of mine supplied goods worth tens of millions to a distributor. Payment was delayed. The client tried every peaceful method: calls, visits, meetings. Then he got information that the distributor was planning to move assets and shut down his warehouse. In simple terms, the man wanted to vanish and leave the debt behind. If we waited till full trial, there might be nothing left to recover. Winning a judgment against an empty shell is useless. So we approached the court for a freezing order. This type of injunction prevents a person from moving or hiding assets pending trial. The court granted it, and the distributor could not touch certain funds and properties until the matter was resolved. Eventually, because the pressure was on, he came back to negotiate and settle. The lesson here is that injunctions can secure your recovery of funds before it becomes impossible. So you can see that injunctions are not just legal grammar, they are a business survival tool. Now you may be asking, barrister, can anybody just go into a court and get an injunction? No. Courts do not give injunctions like pure water. There are strict rules. Here are the main things a court looks at in simple terms. 1. Do you have a legal right worth protecting? The court will ask, what right of yours is being threatened? Your tenancy rights, your trademark, your contracts, your money, your property. Number 2, is there a serious issue to be tried? The court is not deciding the whole case yet, but it must see that your claim is not frivolous. Number 3, will you suffer damages that cannot be repaired with money if the court does nothing? This is a big one for businesses. Loss of customers, loss of goodwill, destruction of reputation, and shutdown of operations. Number 4, balance of convenience. This simply means who will suffer more if the order is granted or refused. If refusing the order will kill your business, but granting it only delays the other side, the scale favors you. Number 5, clean hands and full disclosure. You must come to court honestly, no hiding facts. Courts hate tricks in injunction matters. The 6th thing is undertaking to pay damages. This is like you promising the court that if it turns out later that the injunction was wrongly granted, you will compensate the other side for whatever loss they suffered because of it. So injunctions are powerful, but they come with responsibility. Now let me give you practical examples of business situations where you should think injunction immediately. 1. Let's say a landlord or a government agency is about to lock your premises unlawfully or demolish or seize business equipment. A second example could be someone using your business name, logo, product design, or online identity to mislead customers. A third example could be an ex-employee about to take your customers list and trade secrets to a competitor, especially where there is a non-disclosure agreement or a restrictive covenant. A fourth example could be a partner or a director trying to empty company accounts or move company assets secretly. A fifth example could be a debtor preparing to disappear with your money. Or you have a supply contract and the other party wants to quickly terminate in a way that will cripple your business, and damages will later not be enough. In all this, speed matters. You do not want to wait till your business has gone down before acting. Let me also warn you, injunctions are not a weapon for bullying people. Some business owners think they can use injunctions to intimidate competitors or stop fair business. Courts punish that. If you come to court with dirty hands, or you mislead the court, or your case has no substance, the injunction can be refused. And not only that, you will pay heavy costs. So always get proper legal advice before you rush to court. Now let me end with this. Every successful business is built on 3 things: money, reputation, and continuity. Injunctions protect all 3. They protect your money from disappearing, your reputation from being damaged, and your operations from being stopped suddenly. If you are running a business and you see a threat that can destroy your business before a normal case in court can be heard, do not just panic. Talk to your lawyer quickly. Get the court to press that pause button before it's too late. If you found this video helpful, share it with a business owner who needs it. Subscribe for more practical legal guides that protect your business and your future.